Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Please be seated. Good morning. We have just two cases for oral argument this morning. And on my right, Judge Bacharach from Oklahoma City. On my left, Judge Phillips from Cheyenne, Wyoming, Denver. So you've got a good representative of the 10th Circuit, geography.
And the NBA West.
Oh, yeah. Go Nuggets. That's the
Already
The
dissension.
recording's on. Is not on, is it? All right, let me get organized here and we'll get started. Okay, our first case is 24-9548 Energy West Mining versus Schilpp. And Mr. Mattingly, the appellant, you may proceed.
May it please the court, my name is William Mattingly, and I hope to save 3 minutes for rebuttal, but we'll see how I do. Admittedly, this is a very unusual case to be presenting to the court. We're back a second time. I think we're back a second time in part because there was some confusion over the published decision, which I thought was very clear, which the agency did not think was as clear. I thought that the published decision was very straightforward, that this court felt the medical opinion by Dr. Tomaszewski explained there was no clinical pneumoconiosis and there was no legal pneumoconiosis. He found other diseases and was quite expressly specific and precise in explaining why he believed those other diseases were not related to coal dust exposure. This court agreed that the first administrative law judge simply failed to consider the deposition where Dr. Tomaszewski further explained his opinion, sent it back to the Benefits Review Board, sent it back with the board being advised it was to their discretion whether it needed to be remanded back to an administrative law judge to resolve the question. The board took more time than I think they should have, eventually sent it back. There was a retirement among the administrative law judges. It was eventually reassigned. New judge took the case. He wrote a multi-page decision, gave 3 reasons after he looked at the medical information. None of those 3 reasons make sense. The first reason, Dr. Tomaszewski.
Mr. Mattingly, before you get into those, and I'll ask the same question of your adversary. Do the first two rationales matter since the BIA skirted those 2 rationales and only relied on the ALJ's third rationale?
The standard review of this court allows you to look at the Benefits Review Board's decision and or the administrative law judge's decision. So it is always maybe it's an overly protective position that I need to address the administrative law judge's decision, but you're absolutely right. The board filtered it down, dropped a footnote and said, we found one reason, we're not going to look at the other reasons, go away, which always irritates me because I would like to know why I'm wrong on the other reasons if I am, or if the board agrees with me, because I think in this case, they would have agreed with me. And I always wonder if that's why that footnote's dropped, because the first reason, Dr. Tomaszewski didn't cite any medical treatises, simply makes no sense. There is no requirement that an expert witness cite a medical treatment based on his experience and expertise for every point he makes. And when you look through his deposition, he explains what he found, the pathologic presentation, and then said, I'm not quite sure, very honest, I'm not quite sure what caused this. Here are several options, but I am certain of this. It wasn't coal mine dust. And why am I certain of this? Because the presentation does not have black pigment, which is the key. There had to be some cause and effect between the changes and black pigmentation showing not only exposure, but a reaction of the lung tissue. So his explanation was quite, I think, convincing. And the first 2 reasons that ALJ Swank gave, he didn't cite any medical treatises, so therefore it was conclusory. And that he said it was unknown simply just don't stand up to any criticism.
The medical literature, My understanding is he didn't say you have to cite medical literature or we will disregard everything you said. Just noted that there wasn't any cited, which that goes to the weight, doesn't it? In other words,
It does, except the way he did it, Judge Phillips. He said it was conclusory, and as I read this court's decision, you concluded the opinion from Dr. Tomaszewski was not conclusory. He explained why he found as he did. And for Judge Swank to say it's conclusory because he didn't cite medical treatises flies in the face of that. So that was one of the reasons that his opinion, Judge Swank's opinion, simply can't be affirmed. I understand the point.
Wasn't it a credibility determination?
I don't think it was a credibility determination because he didn't explain it. He just said it was conclusory. And quite frankly, I don't know what kind of medical treatises he would have wanted Dr. Tomaszewski to cite. Dr. Tomaszewski did refer back to the 1979 Archives of Pathology and Laboratory Medicine article to establish the existence of clinical pneumoconiosis, but then he moved on to the other diseases. And interestingly enough, the University of Utah pathology report and the reviewing report that was from the Mayo Clinic paralleled with Dr. Tomaszewski's diagnoses very well. They all agreed. They saw nothing related to coal dust exposure. It was primarily the constrictive bronchiolitis that was present.
Mr. Mattingly, the rationale that there's no particles, there's no coal, micronodules or cold macules, that also coincides with the regulatory definition of clinical pneumoconiosis, correct?
It doesn't. And here's why I have that opinion. When you look at the regulatory definition, it requires that there be a fibrotic reaction.
In addition to
Correct.
the presence, so it was half of the definition
Yes.
of clinical.
It was a component, it
pneumoconiosis.
didn't fulfill the definition.
And so the ALJ and the board say that, well, there is, you would agree, would you not, that there can be legal pneumoconiosis without clinical pneumoconiosis?
Absolutely.
And so if the rationale for rebutting the presumption that the exposure to coal mining dust, or that is that the lung function, the impairment of lung function and pulmonary function arose out of coal mine employment, was predicated on part of the definition of clinical pneumoconiosis. And the ALJ says, well, that can't logically be a rebuttal of legal pneumoconiosis because that is an integral part of the definition of clinical pneumoconiosis. What is the fallacy in that logic? It seems quite logical on its face, doesn't it?
But that's not what Dr. Tomaszewski explained. Dr. Tomaszewski explained there's no clinical pneumoconiosis because there's no macular or nodular disease. There's no contrary evidence. That is supported by the x-rays and the CT scans. He then explained we have these two other things. The bronchiolitis was not from coal dust exposure because when coal dust affects the airways, it causes an entirely different disease process. As he explained, you have macular disease caused in the small airways from coal dust exposure. That's not constricted bronchiolitis. It's an entirely different presentation on the bronchioles. And then the interstitial fibrosis was an infectious process that had nothing to do with coal dust exposure. And he explained when he looked at the biopsy slides, the coal dust was not in the lung parenchyma, the spongy part of the lung, but it was primarily in the pleura. Think of the lung as an orange. The pleura would be the white underneath the skin part of the orange. And when the lung functions, it gets rid of foreign bodies and moves it to the pleura. That's what you expect. That's not a disease process. That's a marker of exposure. That was the words he used. I went back and reread the deposition. And even with 20/20 hindsight now, I don't know that I would have asked him any other questions to have him explain why he did not find legal pneumoconiosis in this case. Because even in his report, he was clear early on that it was not legal pneumoconiosis. Because after he explained that he found constrictive bronchiolitis and interstitial fibrosis, and that the cause was multifactorial, it was not within a reasonable degree of medical certainty the result of coal workers' pneumoconiosis, mineral dust-related small airways disease, or diffuse interstitial fibrosis due to coal dust exposure. That covers the definitions of clinical pneumoconiosis and legal pneumoconiosis. I think those last two expressions that he had explain why this wasn't another chronic dust-induced lung disease. And that's what legal pneumoconiosis is.
Are you saying that no reasonable adjudicator could have rejected Tomaszewski's testimony? Or are you saying this adjudicator failed to adequately explain his rejection of Tomaszewski's testimony?
I would like to say no reasonable adjudicator,
That's what I've been hearing.
but I realize that it still is the ALJ's role to be the fact finder and to say yay or nay when they weigh opinions. But there's no contrary evidence here. So he's left with a medical opinion that is explained, that has been consistent throughout the reports and in the deposition. So I do go to that far side of the camp saying no reasonable adjudicator here presented with this record could reach a different conclusion.
What if the adjudicator discounted the testimony? You're saying I guess the government had the burden of having some contrary medical evidence that's not in this record?
Yeah, there is no contrary evidence to counter my rebuttal evidence with Dr. Tomaszewski.
You should have won on the equivalent summary judgment in this case. Got it.
And the confusion in this case seems that it's over clinical and legal pneumoconiosis, but it doesn't have to be that confusing to me because legal pneumoconiosis is still defined as a chronic dust disease of the lungs. And this expert explains, in the two diseases I found, there's no chronic dust that would have incited either of those diseases to be present in the lungs. So the agency just didn't do their job in looking at this record and, in essence, agreeing with me that the presumption of legal pneumoconiosis was rebutted in this case.
Or is it an argument that the agency is wrong in creating this link that shouldn't exist? If the agency posits that there is a presumptive nexus between any impairment of lung function and 15 years or more of employment in a coal mine, then we presume that there's this nexus. And as I understand what you're saying, Dr. Tomaszewski says is, well, I rebutted it, this presumption, because I concluded that there was no deposition of these particles in the lungs, and so that impairment of lung function couldn't have been related to the employment in a coal mine for 15 years. But that's precisely the presumption. And so it seems to me that you have to have some alternative explanation. It was a genetic, he had this, he had no deposition of particles, and so this impairment of lung function, this chronic bronchiolitis, must have been some genetic, there was a genetic marker, or he smoked for 30 years, and that there were these alternative causes. But to say that there was no rebuttable, that I rebutted the presumption, seems to be, in effect, that there should have been no presumption in the first place.
So remember, there's two ways to rebut the presumption. I can rebut it by showing there's no disease,
Right.
or you can rebut by showing disability was not due to. I'm trying to rebut by showing no disease.
Right, disease causation.
Correct. And in this case, there's no legal pneumoconiosis because none of the abnormalities were related to coal dust exposure from a causal standpoint. And he did explain why he thought it might be idiopathic or unknown, but there were other reasons that he explained that he attributed the chronic or the bronchiolitis or the interstitial fibrosis to. I'll save a minute for rebuttal.
I'll give you some rebuttal first.
Thank you.
Good morning, Your Honors. May it please the Court. I'm Brad Austin. I'm here today representing the respondent, who is now Sandra Schilpp. And of course, Sandra Schilpp is the daughter of the original coal miner in this case, Mr. James Lyle, who filed this claim in 2011 and pursued it up until he unfortunately passed away in 2018. After his passing, his widow, Joanne, pursued the claim for 2 years until she passed away. And so now Sandra is pursuing the claim. Your Honors, I think, especially Judge Timkovich, when you asked Mr. Mattingly, I want to cut straight to the chase. When you asked him, could a reasonable fact finder have found Dr. Tomaszewski's report did not rebut the presumption, and he said, of course, I don't think so. That runs afoul of what this court did when it remanded this case. If that were the case, that a reasonable fact finder could not have possibly found that Dr. Tomaszewski did not rebut the presumption, this court could have reversed the first time around. But the true issue here is that a fact finder the first time around, with Judge Romero's opinion, did not consider all of the evidence. And this court got it right in its published opinion. Judge Bacharach and Judge Timkovich, you were on that opinion, and you explained quite clearly that there was a mandate on remand. You have to consider all of the evidence, and you can't simply say the doctor didn't explain himself, because the doctor did explain himself. But there's a big difference between a physician who explains himself and a judge discrediting on that sole reason, and a physician who explains himself and the judge not crediting it. On remand, the case was reassigned to Judge Schwenk. Judge Schwenk engaged in a 2-page single-spaced analysis where he summarized Dr. Tomaszewski's opinions. He went in and explained himself and provided various reasons for why he didn't find Dr. Tomaszewski's opinion persuasive. That's what fact finders do. That's a battle of the experts. That's a weighing of the medical evidence. Now, in this case, there wasn't necessarily a battle of the experts because we didn't have an opinion that is contrary to Dr. Tomaszewski's, but my client was entitled to the 15-year presumption. It's a presumed fact until proven otherwise that he suffered from both clinical, legal, and disability causation. Now, the employer did rebut clinical coal workers' pneumoconiosis, but what it failed to do was rebut legal coal workers' pneumoconiosis. And Judge Schwenk outlined various reasons that are supported by substantial evidence for doing so. At the end of the day, that's what this case is. It is a substantial evidence case. Judge Schwenk explained himself. There is evidence to support that, and it's really that clear. Now, when this case was before this court the last time around, there were all kinds of issues. The case has been significantly narrowed since that time. This is the only issue we have. So when you look at these reasons that the fact finder gave, unlike the first ALJ, Judge Schwenk fully considered the deposition transcript of Dr. Tomaszewski. And I agree with Mr. Mattingly. Dr. Tomaszewski does explain himself most completely in that deposition. But you need to understand, Mr. Mattingly was not the only attorney who got a chance to ask questions of Dr. Tomaszewski in that deposition. I asked some questions as well on cross-examination, and I'd like for the court to go in and review the entirety of the deposition transcript.
Well, we have. Are there any particular parts of the deposition
Absolutely.
that show this differentiation between the clinical and legal?
Well, Your Honor, I think he did acknowledge on cross-examination that there was minimal dust deposition within the lung tissue. He acknowledged that there was emphysematous changes, although he didn't believe that they were the type of emphysematous changes that were caused by coal mine dust exposure. He did acknowledge in the deposition that he had a significant and substantial coal mine dust history that in a susceptible host might cause disabling coal workers' pneumoconiosis. And at the end of the day, Your Honor, there are other reasons besides, just the clinical. The judge did factor in the failure to cite medical literature, and I wanted to talk about that for a moment. It's a bald declaration to just simply declare that another disease process besides coal mine dust exposure and legal coworkers pneumoconiosis caused.
Why do
the-
we care about that or the second rationale? This is the BI, since, now, Mr. Mattingly said we can, I guess, have our choice of who to review, but it could be and/or, but who do you think we review? The BIA, which, ordinarily in immigration cases, I think that's what we do. But now in bankruptcy cases, we, review the bankruptcy judge's decision. What do we do in a pneumoconiosis case? Do we review the board's decision or the ALJ's?
I think you review both. I think you review the board's decision. In this particular case, I don't think that necessarily matters because I think the sole reason that the board did state
Okay.
would be affirmed. But for the sake of answering your question, because I don't want to sidestep it, I think you still are entitled to review the full opinion of the administrative law judge based on substantial evidence. That's mine.
Okay.
So,
De novo.
yes, Your Honor. Yes, correct. So as I was stating, there's various reasons. Number one, Judge Schlenk did review the deposition transcript. That's what the previous ALJ did not do. Number two, Judge Schlenk fully understood Dr. Tomaszewski's opinion, and that's evidenced by him outlining the opinion in his decision. Two-page summarization. Mr. Mattingly is not arguing that he improperly outlined the opinion, so of course the judge fully understood it. That's something the previous ALJ did not. He was unconvinced by the etiology of constrictive bronchiolitis and interstitial fibrosis because of the failure to cite medical literature. And the reason,
Not only that,
I'm sorry?
not only that, but on page 14, because that's not something that's called, this is a quote, is it something that is caused by exposure to coal mine dust? Answer, no, it is not. So it's not only the failure to cite medical literature, it's his independent conclusion as a doctor that chronic bronchiolitis is not attributable to exposure to coal mine dust, in his medical opinion. Now, why would that be an independent basis to rebut the regulatory presumption of a nexus to cause disease causation?
So let me make sure I understand. Your question is, why would that statement from this medical expert in this case not be an independent
Why wouldn't
absent?
that contradict what the ALJ said? That it's not a conflation of clinical and legal. He's actually giving a medical opinion about why chronic bronchiolitis does not arise out of coal mine employment.
Proving that chronic bronchiolitis does not arise out of coal mine employment does not necessarily eliminate, even if accepted, the possibility of legal coworkers pneumoconiosis as an additive contribution to that process. And I think that's what the ALJ felt when he reviewed the report, was that he had not completely excluded the legal pneumoconiosis that was presumed in this case as a factor in the ultimate decision. Is that?
I mean, if the question is it something that's caused by exposure to coal mine dust? The question was, is that the sole cause of, is exposure to coal mine dust the sole cause? Is it something that's caused, is it your interpretation of that exchange that when he said, when the question is it something that's caused, that's one of the partial causes? Is that how you read that question?
What he's saying in that portion of the deposition is that in his experience and based on what he understands in the medical literature, I guess, that it's his opinion that that particular condition is not caused by occupational exposure to coal mine dust. It's not that he didn't say that. It's that the judge didn't accept that as fully explained within the context of this record. So that's kind of what you had the first time around, was that the judge kind of just summarily said, I don't think the doctor explained himself. It's clear the doctor did explain himself, but the judge was not convinced by that. And that's what fact finders do. He looked at the regulatory definition of legal coal workers pneumoconiosis, looked at the federal registrar that talked about how coal mine dust can arise out of various, many different ways, many different types of disease processes and their sequelae can be legal co-workers pneumoconiosis. And that bald declaration alone was not sufficient to convince the ALJ that he had rebutted legal.
I want to ask you, and I don't want you to, this to sound like I'm arguing with you, because
Sure.
I'm not. I'm just really trying to probe this, because I'm not a doctor. I've never pretended to be a doctor. So, but it seems to me that the ALJ did not, ALJ Schwank did not reject Dr. Tomaszewski's opinion based on a lack of credibility. I mean, there was references to, he didn't cite medical literature. But the third rationale seems to be not a rejection of his credibility or persuasiveness, but that he committed a legal error by conflating clinical and legal pneumoconiosis. And this passage suggests to me that, well, maybe he wasn't conflating the two. He was giving an independent reason that even though he doesn't have coal miners' pneumoconiosis clinical, that it doesn't arise, that chronic bronchiolitis doesn't arise out of coal mine employment, because that's just, otherwise, you would see these, particles in the lung tissue.
Your Honor, I mean,
Am I wrong about that? I could be.
I disagree, but I understand your point. I think Judge Swank clearly explained in his medical opinion that he finds that diagnosis, that you have to have macule or nodularity in order to diagnose legal co-workers pneumoconiosis. I mean, he has to apply his own rules within the agency. And 65, Fed Reg 79,941 and 20 CFR 718-201A2 clearly state that you don't need that in order to make a diagnosis of legal co-workers pneumoconiosis. And I think, given the fact that claimant enjoyed this presumption, it was on the employer to fully convince the ALJ that that was not the case. And so when you have an opinion that he interpreted to be at odds with what the regulations say, I think it's a reasonable position for the fact finder to not be convinced by that argument. Now, perhaps another ALJ may have looked at that exact same evidence and weighed that differently, but I think that's a factual determination for the trier of fact. And I think the judge fully explained himself. He certainly tried his best to go out of his way to explain exactly what he was finding. I think he did show respect to this court by outlining everything that this court found, outlining everything that came from the board, and he went in and tried to provide many separate reasons for what he did. We don't impose a duty of long-windedness on an ALJ. We don't impose perfection on an ALJ. I think the standard is, can you figure out what the judge did and why he did it, and could a reasonable mind have reached the same conclusion? In this case, I do think a reasonable mind could have reached the same conclusion, and this court should affirm the decision from the ALJ on remand, as well as the decision from the Benefits Review Board. Does the court have any additional questions?
Hearing none, thank you.
Thank you, Your Honor.
And Mr. Mattingly, you have some rebuttal. Could you give him 2 minutes, please?
2 points I'd like to make on rebuttal. Judge, there's a presumption of disability due to pneumoconiosis. It's not a presumption that any lung disease a coal miner has was caused by coal mine dust. So to rebut that presumption, you can show that there's not clinical or legal pneumoconiosis. Everyone agrees here there's no clinical. Then the question becomes, are these other changes those of legal pneumoconiosis? Dr. Tomaszewski in his report and in that passage of the deposition, which is the page before the passage that was cited in this court's decision, I think explains very precisely these are other diseases. These are not related to coal dust exposure. And contrary to what Mr. Austin said, Judge Swank never addressed that page of the deposition and never acknowledged that Dr. Tomaszewski in his reports and in the deposition explained that simply those diseases were unrelated to coal dust exposure. They're not known to be caused by coal dust exposure, and there wasn't any significant coal mine dust associated with them to allow him to conclude that there was some type of nexus from a medical causation standpoint. So I guess back to Judge Temkovich, a reasonable fact finder can't reach another decision in this case. Dr. Tomaszewski's opinion is fully reasoned. It deserves full credibility. It rebuts the presumption of legal pneumoconiosis.
Can I ask a question about how that applies, that standard applies in this case? Typically, when we consider substantial evidence, there's a finding, the defendant robbed the bank, whatever, that there was enough evidence to support it. Here, the third rationale of Judge Schwank is that there was a conflation of clinical and legal. On substantial evidence, is the question as applied in this context whether a reasonable judge could interpret Dr. Tomaszewski's deposition testimony as a conflation of clinical and legal pneumoconiosis? Is that how that substantial evidence applies in this particular context?
I think that's the first question you have to ask. Could his opinion conflate the two? And I don't see how. And then the second question is there substantial evidence in the record that supports rebuttal? And is there anything contrary to that? And in this case, the only evidence is Dr. Tomaszewski. It rebuts the presumption of legal pneumoconiosis. So it's a two-pronged question.
Okay.
All right, counsel, thank you. Your time's expired.
you.
We appreciate the arguments. Counsel's excused and the case shall be submitted.
Can I just comment? Mr. Manley, I appreciate you letting us know it is valuable to know when our decisions are not clear to another tribunal. Everyone strives for clarity, so it's really helpful for me personally, and I think for all of my colleagues, to know that.
Thank you.
We fall short. We're fallible.
It's better to build bridges than to build walls, so it makes life easier for all of us.
All right, counsel for Earthgrains, you may come forward. All right, looks like we're ready. This case is 24-4085, Earthgrains Baking Companies versus Sycamore Family Bakery. Mr. Heidemann.
Good morning, Your Honors. My name is Justin Heidemann of the law firm Heidemann & Associates, and today we appear at the pleasure of the appellant Sycamore Family, LLC. Your Honor, it is my sincere hope that the following argument may be found pleasing by this court. We would request a rebuttal of 3.5 minutes. The appellants posit that two specific exchanges from the trial court highlight the error committed in this case. In the amended judgment, Appellant's Appendix Volume 1, 204 to 206, the trial court states, pursuant to the orders entered in this case, the verdict of the jury filed on April 13, 2012, the July 2015 or 2014 order and judgment of the United States Court of Appeals for the 10th Circuit and the court's memorandum decision, and order entered on August 21, 2015, all claims in this lawsuit having been resolved, tried, or stipulated. And this court amends the July 16, 2012 final judgment and enters the amended final judgment as follows. That order concludes with this statement. Each of the previous orders and decisions entered by this court in this case remain in effect, except where otherwise reversed by the 10th Circuit. 9 years later, the trial court, in response to appellant's motion to terminate the judgment, enters the following statement. Quote, "In this case, the amended final judgment amended and superseded the final judgment. Defendants appealed the 2012 final judgment and obtained a favorable decision from the 10th Circuit invalidating the 2012 final judgment and requiring this court to enter the amended final judgment." That language is found in the appellant's appendix, volume 2, 236 through 240, specific language 237. These cannot be read to be consistent. And as a result of these statements, it is clear where the error lies in this case. I would note for the court that on issues 1 and 3, the parties agree as to the standard of review. But as to issue 2, the standard of review is in contention. I will address that through the course of this argument. However, I would start with the simple fact that if the court follows the state of Utah's plain language law, which this court has indicated in its prior appeal in this matter that it does so by simply looking at the plain language of the statute, that this case terminates as a result or with the result that reverses the trial court's decision. In this case, there is a specific statute at play that requires that from the date of the original judgment, there is an 8-year time frame.
So the 2015 judgment would last for 8 years?
No, the 2012 judgment would last for 8 years.
So what in that plain language of the statute saying that a judgment lasts for 8 years would apply only to the 2012 judgment, even if it survives in addition to the 2015 judgment? Is the 2015 judgment a nullity?
No, it is not, Your Honor. The 2012 judgment, or the language of the statute specifically states that the original judgment uses those two words in conjunction. Yes.
Can be renewed.
Yes.
The statute, there's two statutes. The one you were referring to doesn't use the word original.
Correct.
And so it says that a judgment lasts for 8 years.
Correct.
And the caption of the 2015 document has the word judgment in it, right?
Specifically, Your Honor, I'm referring to Section 78B 5202, and what that expressly states in subparagraph 1B is that the entry of an order renewing a judgment maintains the date of the original judgment.
And that's not the statute I'm asking you about.
Okay, and that's
I'm
why
asking you about the one you were talking about just a moment ago, not the renewal. That, let's say there's no renewal. The statute that you were just referring to saying that a judgment lasts for 8 years.
Correct.
Why wouldn't the 2015 document, it is a judgment.
Correct.
Right? So why doesn't it last for 8 years, even if it can never be renewed?
Excellent question. And Your Honor, I think the answer to that is because of the fact that the renewal statute identifies specifically the original time frame. And in fact, it's interesting, in a case cited by counsel, I'm going to get the name wrong, so I'll point to it. It is this case, cited at the very end. It's the Jurgensen versus Ford case. Jurgensen versus Ford goes through and actually identifies the public policy reason that answers the court's question. The judgment itself operates to create effectively a collection effort, and in this case, the 2015 effort would go into effect. But as Jurgensen points out, the operation of the original judgment is what creates an issue associated with the property. And as a result of the fact that there is a necessity to be able to identify ownership and encumbrances on property, we go to the original judgment, not the amended.
Let's say that is, we are 100% persuaded. Well put. It sounds very persuasive. But you just told us that we have to, we can't use our own policy preferences. We can't go behind the words of the statute.
Correct.
And the words of the statute, not the renewal statute, just the duration of a judgment, it sounds to me pretty unequivocal, pretty unambiguous, that judgments last for 8 years. And so even if it maybe was counterproductive by the legislature to say that any judgment lasts for 8 years, we're stuck with the plain language of the statute.
And this goes to the second point I was about to make, and again, I think it's an excellent question. I've spent hours toiling over this particular issue. Toll is on my mind, apparently. But in this particular instance, I think there's one date that gets overlooked, and it's one that cannot be, and that's the March 6, 2014 date. Your Honor, the charging order was entered that day. The amended judgment was entered in 2015. The amended judgment only amended one line. And it just simply identified that there was a LLC forfeiture with regard to two state, or with only one state, California, instead of two, Nevada and Arizona. It didn't change any of the economic elements. And the reason that's critical is because of what happens in 2018. In 2018, on November 2nd, the receiver is appointed, and the court expressly says, in reliance on the charging order and the failure to collect, I find it necessary to put the receiver in place. The charging order predates the amended judgment. And so as a result, it's clear to me that although the amended judgment amended an element of the judgment, it did not change the fundamental nature of the judgment, which was the amount to be collected. And in fact, that judgment is what is relied upon. Otherwise, the charging order is a legal nullity.
Don't we think, though, in other contexts that an amended judgment supersedes that which preceded it? You obtained a reversal in part in the 10th Circuit. It goes back, and the district court had no choice but to enter a new judgment that conformed with what the case was now about. And
I 100% agree.
And so it reaffirms what it found before and fixes what the 10th Circuit said was erroneous. And but you think that judgment, that document, is what the plaintiff needs to go, show an enforcement officer, or maybe you came back up to the 10th Circuit, whatever.
Let me make sure I understand the court's question. I think I do. I agree 100% that the new judgment supersedes the old. What I don't agree with, and what I think the legislature of the state of Utah does not agree with, is that it changes the timing for the renewal period.
But in most other contexts, the federal rules, the later in time judgment would be the operative judgment. That's what we would look at.
I agree.
And you're saying because of the statutory language, that's out the door.
Well, and I think, Your Honor, it's also important to take a look at what happens with regard to the construction in the case I just referenced. I keep saying the name incorrectly. Here we go. Jorgensen case. I want to say Yazd, and it's Jorgensen. Yazd is a famous Utah case. In that particular instance, the court identifies that you only get one additional 8-year period. So when your judgment is entered 8 years later, if you renew it, you don't get to renew again. You get 2 periods of time, and the court sets that period of time based specifically on that statute, and the statute says the original judgment. It does, if they wanted to say a superseded judgment, if they wanted to say an amended judgment, they would have, but they did not.
Could Earthgrains have been pursuing collection efforts during the appeal to the 10th Circuit?
They did. They did. If you look at, in fact, that's one of the specific elements. If you look at the November 15th, 2019 report, which is the 14th status report, the court ordered $1.1 million be distributed. And then we find out that on December 20th, 2021, there was a distribution of $1.375 million.
I'm talking about between 2012 and 2014.
Yes, they did. That's where these funds came from.
Okay.
The court entered during the, well, and to be very, very specific, there was an appeal that was taken in 2020. And when that appeal was filed, there was only 4 months left on the statute of limitations, or on this renewal period. That notice created a circumstance where there was a 57-day complete stay. But this court affirmed in part and denied in part, and what it affirmed was that the liquidation stay was still in effect, but the collection stay was never in effect after that order. So they had the ability to collect at all times.
Well, let me ask my question a little differently in the form of a hypothetical. Let's say you've appealed the 2012 final judgment, and for whatever reason, the 10th Circuit doesn't get an opinion out for 8 years.
Mm-hmm.
And I think I hear you saying that the plaintiff had to enter its collection actions during that period, or even though there was not a decision from the Court of Appeals, would have to file for renewal?
Okay, no, Your Honor, that's not what I'm saying. If you look at the Gilead case is very clear that whenever there are stays vis-a-vis operation of law, which is this plain language of the statute, or whenever there is a period where there's an adverse ruling that precludes an activity, that equals an equitable tolling event. And I'm sorry, I said Gilead and I should have said Stinson. That's the Stinson case. And so those periods of time would allow for tolling, but that didn't happen here.
Well, it didn't happen. There was a specific statute, there's two arguments that have been presented, and you seem to conflate the statutory stays and the equitable stays. The judge concluded that because of improper conduct from Mr. Sycamore and the LLC, that should count as an equitable stay. The statute specifically enunciates, however, I think 78.5B202, that there is a separate provision for statutory stays, and the statutory stays, I think, come up, if you total the math, I think it comes up to 1 year and 364 days. And so that 1 year and 364 days, even if you're right on the Gilead case, that would affect the extension of the operation of whatever judgments involved, correct?
No,
But you've never argued otherwise.
we have.
No, you haven't.
Okay.
So in your reply brief, you say, I'm not trying to argue, I shouldn't say that. In your reply brief, you said, yeah, we have absolutely argued that there shouldn't have been any equitable stays.
Oh, I see, I'm
And
sorry.
he keeps saying, I know that. I'm arguing about a statute, the statutory stays.
You're correct, that's not what I was saying.
All right.
What I was saying is, it doesn't matter, because none of the stays went into effect until the time had already expired. If you look,
If we say the 2015 judgment doesn't really matter.
that is correct. If you say the two,
Say the 2015 judgment matters, that goes, I'm not a supreme mathematician, but even I can add 8 years to 2015
It's
is
2023.
2023. And if I add 1 day shy of 2 years, you're in 2025. And so in 2024, the termination of the charging order would have preceded the expiration of the 2015 judgment with the addition of 1 year and 364 days.
and this is where I think the court has to take a very close look at the timing of when these stays were issued with regard to the operation of law. Those stays took place when the first appeal was filed, which is in 2020. That's a 57-day window. They don't file within that 57-day window. The next stay comes after the 2023 date. And so that doesn't matter. So the only thing that matters, that's why we didn't argue the statutory, the only thing that matters is equity, and they were able to collect the entire time. And so as a result, Gilead makes it very clear, unless you're somehow precluded, you don't get there, which is why we come, and I'm almost at time, so I'm talking fast, which is why we come to the issue of the second item, this equitable tolling. No Utah court in the history of the state has ever applied equitable tolling when the dates were known. And I would note for the court, there was a case that was issued 35 days ago by the Court of Appeals. It is not even published yet. It is a slip opinion. I've got the citation for you if you would like it.
You can submit a 28J letter.
I'm sorry?
You can submit an authority afterwards.
We will. I just want the court to know that it came out. But the whole point here is that even as of 35 days ago, it is consistent. And in this case, all they had to do is file a motion. That's it. That's all they had to do. Every single case that they identify for this court predates the Renewal Act. The Ford opinion, even Gilead, all of those opinions predate this act. It was created in 2011. There is simply no ability for the court to look at this language and say, oh, we're going to apply some equitable issue here. It doesn't work that way, not with the statute. I see I'm out of time. Are there any other questions?
Thank you, counsel.
Thank you.
Good morning, Your Honors, and may it please the court, Alan Moritzen for Earthgrains. Covered a fair amount of ground this morning. I think the court can resolve this appeal quite, quite straightforwardly based on the standard adopted in Gildea, which was in 2015, 4 years after the renewal statute was passed. And the standard in Gildea states that a judgment debtor cannot assert a judgment's expiration as a defense if the judgment debtor acts in bad faith to prevent the judgment creditor from enforcing the judgment. That principle is grounded in equitable estoppel. It's what Judge Kimball, who has lived with this case for more than 15 years, relied upon, at least in part, to hold that the judgment had not expired, or at least that the Sycamores were prohibited from arguing the judgment's expiration as a defense because they had engaged in bad faith conduct with respect to the judgment creditor's efforts to enforce the judgment. And if you look at, and this ruling was issued on November 2nd, 2018, more than 4.5 years after the original charging order had been put into place. So over that entire period of time, the Sycamore family had paid exactly $0 on the judgment, despite Earthgrains' consistent efforts to collect on the judgment. And if you look at page 258 of the first volume of Appellant's appendix, you see Judge Kimball expressly finding that the Sycamore family engaged in willful contempt of the charging order. And based on that willful contempt, they had engaged in bad faith conduct.
Are you saying you never needed to renew them?
On this doctrine, we did not. Essentially, the judgment debtor is precluded from challenging the expiration of the judgment when it acts in bad faith to prevent enforcement of the judgment. That's the standard Gildea adopted in 2015. They applied it in Gildea. They in that case, chose not to find that Wells Fargo had engaged in bad faith. But here you have a poster child example.
I
Yes.
read the district court almost using that as a fallback position, but you're leading with it. Is it your primary argument?
I wouldn't call it my primary argument. I just think it's a clean way, based on Gildea and the standard that's set forth there, without having to disrupt or, displace the court's findings on bad faith.
But how clean is it? Nobody ever knows what the answer is to whether you have to renew that way until you get some sort of a bad faith finding. That doesn't seem to comport with what the Utah legislature would want.
Well, I understand the concern, and it is risky to rely on a bad faith finding.
Why did you? Why did you not file earlier?
Yeah, that's a good question, and I don't have a good answer for you. But all I can say is that Gildea says that the judgment debtor can't act in bad faith with respect to enforcing the judgment and then turn around and say, hey, it's expired, your time's run out. And that standard is satisfied here. With respect to the statutory analysis, Judge Bacharach, you hit on the point, I think, which is if you go to 202, you see a statutory enunciation of a tolling period, basically saying if enforcement of the judgment is stayed, then that adds to the duration of the judgment for purposes of the renewal statute. And so here we had a stay entered on March 30th, 2020, that prohibited the receiver from moving forward with liquidating the LLC's real property, which was, according to both the receiver and the district court, the only feasible way to enforce the judgment at that time. That stay remained in existence until March 8th, 2022. So and then the 21-day stay when counsel withdrew. Our math, Your Honor, may not entirely align. I have 729 days. No. I think that is 1 day less than 2 years, right? And so even if we consider September 1st, 2023 as the expiration date for the amended judgment, once you add the statutorily authorized stays to that time period, you end up on August 9th, 2025, more than a year.
But his argument is that we don't look at the 2015 judgment, we will look at the 2012 judgment.
I understand that that's...
What's your rejoinder to that?
My rejoinder to that is that original judgment is to be, original as a term, right, is almost always used as a comparison mechanism. It's a comparison word. right? The original versus what? And here, given that the term original judgment is used in the Renewal of Judgment Act, it makes sense to consider the original judgment to be contrasted with the renewed judgment, not.
So it sounds like you agree with him on the applicability of the language for the original, reference to the original judgment, which is only present, as I understand it, in the renewal provision. It's not present in the provision saying that a judgment lasts 8 years. And so I think, as I understand it, one of his arguments is that you don't look at just the pure existence of 8 years from 2015 because you only look at the original judgment. So you disagree with him on maybe on the significance of the original judgment, but it sounds like there's implicit agreement that at least we have to consider the meaning of original judgment in determining whether a judgment lasts 8 years.
Well, and this is partly why I led with the Gildea standard, because I think it's a little bit messier, but I'm certainly not conceding that the amended judgment is not the relevant judgment for purposes of 1802.
And if that's true, then why do we care what original judgment means? Because the phrase original judgment is not in the provision saying that a judgment lasts 8 years.
Well,
that could mean that, well, if it's not an original judgment, it's not renewable. You know, it's not the original judgment. But it's something.
Well, and my point is that you would expect additional guidance from the legislature if it was intending to say that no amended judgment could ever be renewed.
Well, why do you even care if the amended judgment can be renewed? You win, even if the 2015 judgment is never renewable.
Well, if it's never renewable, then with the statutory stays, we are coming up on August 9th, 2025.
But the issue before us is whether or not the motion to terminate the charging order in 2024 was premature.
Fair enough, and I understand that. I mean,
you want to win the war and maybe lose the battle.
Well, we want to win both, as the case may be. But I think if the court were to go that route without addressing the question of renewal, we would find that, acceptable, I suppose, because we still prevail. But I think the larger point is either under Gildea, which again has no stopping point when you engage in bad acts, or under the notion that the Renewal of Judgment Act applies to both amended judgments and original judgments. We are entitled to that additional time that we would be entitled to. And again, this goes back to the intransigence that we have been dealing with for going on 15 years now in trying to collect this judgment, right? Most of these cases arise when a judgment creditor sits on his hands for 6 years or 7 years and then says, oh, wait, I have a judgment, I'm going to go enforce that. That's not this case, right? We have been actively engaged in collection/enforcement efforts since the judgment was initially entered in 2012 and the amended judgment was entered in 2015.
Counsel, could I ask you, while you're on original judgment?
Yes.
And we leave that. The preceding paragraph 1, a motion is filed within the original action.
Yeah.
How do the words original action tie in your mind, and how should we use those words in interpreting what original judgment is?
I'm glad, I'm glad you asked that, Judge Phillips, because I think if you look at Gildea, what you see is a description of how this used to work in Utah, right? This used to work via a separate action. So you had the first case, and then you said, hey, I'm going to go enforce my judgment, but I have to initiate a new proceeding in order to do that. And in our view, that's why the legislature was using original, both in original action and in original judgment, to differentiate between, hey, you used to do this with a separate action. Now you do it within the same action. And so when it says original action and original judgment, it simply means the operative judgment within the existing action, right?
Is it a vestige then, or is does a creditor have the option of the new post-2011 or proceeding under the pre-2011 file another action? Are both available to a creditor still?
My understanding is that both are not available.
Then why have the original action talk?
I honestly think that it is, and if you look at Gildea, and I would encourage you to read this description because they actually highlight the word original in their discussion of this and seem to be suggesting that the legislature was trying to draw this distinction, even though, again, it was no longer going to be operative, but it was telling litigants, hey, we've been doing this for 75 years a particular way. We are changing the way we do it. And the way we do it now is you stay within the original action. And I will tell you that there have been some recent attempts to amend this series of statutes which are not the model of clarity, part of which is to delete the word original.
Well, whatever gave the pre-2011 system of filing another action, did that get repealed?
I believe that it was judicially imposed, that it wasn't statutory, but I'm saying I believe it for a reason. I'm not positive whether the prior statute was repealed. My only point is I think that is the best way to understand why they were using the word original. And it's because, I mean, to my mind, it makes a lot more sense to give it that understanding, given the background and the context, than to state that amended judgments, I mean, imagine an amended judgment is issued 6 months later or a year later. It's strange to me to suggest that the Utah legislature would say, we're just going to ignore any kind of renewal process when it comes to amended judgments, even though they become the operative judgment, even though they supersede the original judgment by definition. We're just not even going to address that. That makes a lot less sense to me than to say they were using original to differentiate between this new proceeding and the old proceeding.
Isn't what you just explained a pretty good argument for your adversary about why Gildea really doesn't have the meaning that you attach to it? Because Gildea is relying on free, which preceded, which was decided under the regime that in order to renew a judgment, you had to file an enforcement action. And so his argument is, well, equitable estoppel, equitable doctrines are predicated on the notion that you are precluded from taking the desired action because of misconduct of the adversary. And there was nothing to stop, even if there was obstruction and improper transfers to Mr. Sycamore's wife, et cetera. There was nothing to stop Earthgrains or its predecessor from filing a motion to renew the judgment. I mean, they had nothing to stop you all from doing that. And that was in Gildea, which held that there was not equitable estoppel in that case, was relying on free in the excerpt that you're relying on.
Well,
so why doesn't that whole explanation that you gave give ammunition to your adversary on what Gildea is inapplicable?
Well, just to clarify, the discussion I'm referring to from Gildea is in talking about why the Renewal of Judgment Act was implemented and how it changed.
Not today. I mean, in your brief, you're relying, and district judges relying on Gildea.
Well, let me just say, the doctrine of equitable estoppel, even though rooted in free, remains viable because this is 4 years. Excuse me, Your Honors. This was 4 years after the Renewal of Judgment Act was passed. So the court could have easily said, look, equitable estoppel doctrine no longer applies because now you can renew.
Yeah, that's my question. Was the judge just wrong in applying Gildea?
No, because read Gildea. I mean, Gildea is very clear that equitable estoppel as a doctrine in this context continues to apply with full force. And you look at the argument, Gildea said, hey, Wells Fargo acted in bad faith. And I see my time's up. Let me just wrap up this thought. Wells Fargo acted in bad faith by filing an answer and asserting defenses and asserting counterclaims. The court could have said, estoppel doctrine no longer applies because we have the Renewal of Judgment Act. It didn't say that. It analyzed whether the evidence before the court showed bad faith. It remains a viable doctrine and fully enforceable. For those reasons, we ask that the court affirm.
Counsel, time's expired. Counselor excused, and the case shall be submitted. Thank you. So did you have, I don't think you had any rebuttal.
Oh, I used it all. In that case, I guess I'm done. I thought I saved some, but I missed it. Okay.
All right, court will be in recess until further notice.